let's talk about recklessness versus negligence.
Okay, so negligence is usually what we see in personal injury cases that we deal with here. So it's a deviation from the standard of care that a reasonable person would use in similar circumstances to yours.
Okay.
Also known maybe as like a mistake or a screw
an
up.
accident.
So I'm driving my car and I'm texting and driving and I rear end someone. Is that recklessness or negligence or both?
I think so. That's interesting. I think that it's clearly negligent, right? You have you have a traffic ticket for using your cell phone while you're driving.
Right. So there's a
that's
criminal
not reasonable
aspect to it.
Well, no.
Traffic.
Yeah.
Yes.
Traffic. Yes. Okay.
It's not really a crime. It's a traffic ticket.
Right.
And then rear-ending someone, of course, would be another ticket. I think both of those are deviations from this normal standard of care, reasonableness, right? That's what negligence is. It's an accident.
But wouldn't you think reckless would also work?
I think the being on your cell phone.
It's obvious that I shouldn't be looking at my
so
phone
reckless
and
is a
distracted
weird.
Yeah.
driving.
Reckless, so is like aware of and consciously disregards a grave risk.
Right. It's a
to
gross
life.
deviation from
Like
the
what?
standard
Give me
of
an
care.
example.
So so you take your hypothetical, but say you're driving 100 with a beer in your hand, a cigarette in your other hand, you're driving with your knee,
Yeah.
and trying to voice text. So now it's so absurd.
Right.
It's
That's
reckless.
reckless.
Right.
Okay.
And there is a misdemeanor in the vehicle and traffic law for reckless driving.
Okay.
Right? And it makes sense that you would be criminally prosecuted for something like that, right? Going 100 miles per hour in a 40 and going through a red light is different than just running a red light, which is an accident.
Yeah. Or
But then on the personal injury side, that would be negligence
Yes.
from the driver.
Right. And I think the cell phone stuff gets complicated.
because we all know, that texting and driving isn't a good idea. It creates a heightened level of risk. I think everyone would agree on that. But there's millions of text messages sent while driving in New York State in a given day. Does sending one text message while you're driving get you to that level of recklessness? I would say it probably doesn't.
Probably not. I actually had a case when I was a district attorney where a woman in Gates was driving with her kids through a busy intersection by a Wegmans. And she saw a for sale sign that she wanted to take a picture of. So as she was going through the intersection, she actually turned around and started taking pictures of the sign. And when she turned around, she started moving her steering wheel to her right. And she actually launched her vehicle into a parking lot and ran over two small babies in a wagon.
Oh my
and they were horribly injured. And I presented to the grand jury vehicular assault charges, which require recklessness. Right? My argument was that, that's more than just texting on your phone, right?
Right.
The act of turning around and taking pictures combined with the busy intersection, right, was a gross deviation from the standard of conduct. That was an unjustifiable risk.
Yeah.
And she ended up pleading guilty to the vehicular assault.
That's sad. Situation. Wow. But
I think that's interesting. I don't
so
think...
that's on the criminal side.
Right.
And then on the personal injury side.
So in personal injury, we
How
only
would-
have to prove negligence. So while
it's
some things
easier
may
to
be
prove.
reckless, some things might be reckless. We don't have to prove recklessness. It's not recklessness is not an element of a personal injury case that we bring. So it's out there. Where it does come into play sometimes is punitive damages. If someone acts recklessly, they can get heightened penalties essentially, or they can have to pay more money because what they did is reckless or wanton or borderline intentional.
Okay.
But for the most part, 99% of our injury cases, we're just trying to show that somebody screwed up, that they caused the injury.
In an instance like that, would you have to wait for the criminal case to be closed to finish the civil side?
You don't have to, but it's great evidence, right?
Right.
If someone pleads guilty to driving recklessly, right?
more proof
And their
to
conduct
show.
was the cause of the injury. Recklessness is a higher level than negligence. And I think that that's great evidence that they were negligent when you're
Okay.
and even reckless when you're bringing your personal injury case.
And a lot of times, what they're pleading guilty to is not even a crime, but it's a traffic ticket. It's following too closely, failure to maintain lane, stop sign violation, 1110A, whatever it is. There's a plea to a traffic ticket, which for our purposes in the personal injury case is just as good. They admit that they broke the rules of the road and someone's hurt. And,
Right.
and that's
Right.
it.
It doesn't have to, be a felony level criminal case like that. Be
Right.
as simple as going to town court and pleading guilty to crossing your lane unsafely.
So what I'm hearing is it doesn't necessarily matter at the level of the criminal act. As long as there's negligence, it's already that person's fault.
Yeah, just to go
The
back.
injury obviously would vary, but the part about just figuring out liability is
Right.
easier to prove.
The standard's negligence, right?
Right.
And that's
That's what we're looking for when
Right.
we're deciding whether or not to take a case. Is there negligence? Did someone cause someone else's injury?
Okay.